Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax and another versus Siddharth Gupta. This case has been reported in 450 ITR at page number 534 and the matter has been decided by Allahabad High Court. The date of the judgment is 12th December 2022. As all we know that in case of search, the assessment under section 153A and 153C is done. The procedure is that before passing the assessment order, the assessing officer will prepare the draft assessment order and it will be presented to the joint commissioner or additional commissioner for their approval, and then the final assessment order will be passed. The main logic for giving this approval is that the legislature wants that some application of mind of some superior authority should be there while passing the assessment orders. Their viewpoint should also be taken care of while passing the assessment orders, and more intellect level should be used while passing the assessment orders. So this is a basically check and balance for the assessment orders which are being passed. But this approval is being done in a very random manner, in a very rash manner, whether it is the approval in case of section 148 issue notices or whether it is a approval of such cases. In this case, the approval which was given was really a very shocking evidence. In this case, there were 3 assessment years involved for the assessee: assessment year 13, 14, 15, 16 and 16, 17. The assessing officer prepared the draft assessment order, presented them to the approving authority, and on the same date, the approving authority gave the approval and the assessing officer on the same date passed the assessment orders. Apart from this, a very unique feature was that on the same day on which the approval was given for the assessees 3 cases, the approval was given for 123 assessees. So it is impossible for a human being to apply his mind for the facts of 123 cases. Not only the facts are involved, but the law point are also involved in case of such cases. A lot of law point is also involved. So when this matter was before the ITAT said that only on this ground that the approval was mechanical in nature, it was without application of mind, the assessment orders are non-est and they have no existence in the eyes of law. When these assessment orders were quashed by the ITAT, the department moved to the High Court and the High Court also upheld the verdict of the ITAT and said that it is not possible for a human being to give the approval under section 153D in 123 assessees, and it is also practically not possible for the assessing officer also that on the same day the draft assessment orders are prepared and on the same day the final assessment orders are prepared. It means that the assessing officer has made his mind to pass the final assessment orders. There was even not a single point of addition or deletion by the approving authority for those assessment orders. So the Allahabad High Court said that there is no substantial question of law in this case and the order stands cancelled. My point is that whether in all those assessees also, the remaining 122 assessees, there will be no validity of the assessment order passed in those cases also, because it may happen that in those cases also there is no application of mind, and when these things happens, there is no action on the assessing authorities or the approving authorities for giving the approvals in such a rash manner. So this point also be taken due care by the courts, that whenever these type of instances happen, there is a lot of revenue loss to the government also, and there is lot of loss of human resources and the financial resources in respect of the assessees. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus SIDDARTH Gupta. This case has been reported in 450 ITR at page number 534. Thank you, friends.